Estate planning comes as a major part of our life history here, and we like to kind of look at things in piecemeal processes sometimes. When we look at RRSPs and a tax season, something that we should be doing all year long is estate planning, and it's not as hard as some people may think. We have Lauren Scharfstein with us today, who specializes in that in one way, shape, or form, and I want to thank you for physically coming into the studio.
Thanks for having me, Randy. Really happy to be here, and happy that the start off is that it's not as scary as people think it is. Estate planning is a good thing, it's a happy thing, and it's something that can help you feel that you've got your life a little bit more in order to make things a little smoother for your family and your loved ones.
I want to ask you then, you are a practicing lawyer with a specialty in estate law, and I think that's one of the good things that we talk about in terms of everyone needs to do something for whatever belongings and things that they want to pass on, whether it's farmland or family home and cars and assets. Tell us a bit about yourself and how that field of interest grew your way.
Well, yes, I'm a practicing lawyer here in Saskatoon at Scharfstein LLP. And I say I try to practice in what I call the happy areas of law. Try to stay away from fighting and litigation if I can, and I stick to primarily estate planning, estate administration, and corporate commercial. And people may think, estate planning is happy? Isn't that about planning for death? And I find it to be a happy area because it's one of those things where you get to sit down and feel secure that you've put things in place to make it both easier for you in the event something significant happens, but also for your loved ones. And it's very much a planning tool to ensure that things are smoother when there is a transition or if something bad happens. So in my mind, that is happy, that's positive. Yes, it's generally planning for something that might not be so great, but getting those things in order can definitely take a big burden off your back and some concerns. And that's where a legal team can be very, very helpful. You come in and generally with one meeting or a few discussions, we then take over the heavy lifting and put something in place that works for you.
So is there a good time to start? If some people say, well, I'm not retired yet, or I'm not over 50, I shouldn't be doing that. Is there a good time to get something written down?
No time like the present. One of the biggest misconceptions about estate planning is, I don't have kids, I don't have a lot, I don't have any money, I don't have a house. And people think primarily estate planning means a will. And that is a big chunk of it. But there's other aspects to estate planning. Estate planning includes a power of attorney, a healthcare directive. Generally speaking, it's looking at assets, liabilities, family relationships, and the whole picture, whether it's transfer of farmland, of a business, or even just the family home, how to structure things so that can be done easier. A will is probably the one people think mostly about, and they say, oh, I don't have anything, or I don't have a house, or I just have debt. That's one we hear lots. So I don't need a will. Big misconception. Your will can be as simple as naming who you want to administer your estate and who should get your stuff. Doesn't have to be any more complex than that. It can be. We can do tax planning. We can do very, very fun things. But if you don't have a will and you don't have someone named to be your administrator, your loved ones are left not being able to access your bank accounts, pay off any of your debts. Yeah. You have to do filings with CRA. Nobody's there to do that. You can't even donate clothes or really do anything. No one has the authority to come in and kind of deal with your stuff. So something as simple as naming your executor, so someone doesn't have to apply to the court to be administrator, which is a very kind of long, expensive, and a bit more of a difficult process. Similar with power of attorney. People think, oh, I'm young, no problem. I don't need a power of attorney. That's exactly why you need a power of attorney. Once you need one, it's generally too late. You need to have capacity to name the person to act as your attorney. And generally when you lack capacity is when you need someone to step in as your attorney. So it's never too early to get that document done, to name the person you trust to help administer your affairs in the event of incapacity or you're unable to do something. And these documents can change with you over time. They're not set in stone. It's not like you do it once and then we lock it away in a vault and you never see it again. So it's something that it's never too early. You never don't have enough or have too much or anything like that. Getting something in place at any point in your life is important.
When you're looking at how to administer your estate and plan for it, there's a definition of equitable and a definition of fair. Is that something that comes into play and you can help families negotiate that?
That's a very good question. We, as in the estate planning world, say what isn't fair, fair isn't necessarily equal, and equal isn't necessarily fair.
Enough, yep.
And that is something that becomes very important in kind of maybe larger estates or different estate planning. Farm succession planning is a big one. If you have a family farm and multiple children, and potentially one is going to take over the family farming operation, whereas others aren't planning to, how do you work around that? How do you keep things maybe fair or equal amongst your children? That's something that we can help plan for and give you options and some different avenues of how to explore that and what that looks like, because that is something that I see weighs on clients' shoulders quite a bit. How do we keep things quote unquote fair if it's not equal? Very, very good question.
And when you look at how your well-being, so if I had a stroke, for example, and was incapacitated and couldn't make my own decisions, is there something that I would administer or that takes effect upon a doctor deeming me incapacitated?
Great question. That goes back to that importance of that power of attorney. So even if you have a will, your will doesn't matter until you pass. That only matters once you've passed and where your stuff goes. If you are going down the incapacity route and say your doctors declare you incapacitated, that doesn't mean anyone is necessarily there that can act on your behalf. Even if you're incapacitated, unless you have a power of attorney document in place that says, I want X to administer or basically step into my shoes and handle my personal and property and financial affairs, we're left in a bit of limbo. You're incapacitated, so you're not able to do it, but you haven't elected anybody to do it. At that point, we're left doing what's called a guardianship application. And that is a lot more of an extensive process. We have to prove incapacity to the court. It costs quite a bit more. And generally, when you've got time-sensitive issues, when someone's incapacitated, you've got to get them in a home, you need access to funds, pay bills. We don't have the luxury of time. So having that power of attorney in place ahead of something happening is so important.
It would speed up the process if it has to be there. And I guess I'm also asking on behalf of people who may be single. I don't have any kids. I don't have a dog maybe, or I'm in an apartment. Is there still a requirement that I have one, or can I just simply write it on the back of a piece of paper and sign it?
Great question. For anybody, whether you've got a large family, a small family, anything, you can write anything you want on the back of a paper, particularly a will. It's called a holograph will, and you can handwrite and sign, no other witnesses needed. Where we see that kind of come into play where there's problems is partly handwritten, partly typed, not with enough witnesses. So I caution against that per se. The power of attorney, better to have something than nothing, but you want to make sure that it's done appropriately and you're following the legal requirements for it to be a valid document. If you don't have a spouse or you don't have people, oftentimes that's when you need to designate somebody, or you need to have that will of who would get your stuff, because it's a lot more complicated of who would step forward to do it. Particularly in the healthcare world, with a healthcare directive, there is a fallback. If you have not named anyone to speak on your behalf for healthcare decisions, your spouse is your fallback. There's no such fallback for a power of attorney, no such fallback for an executor of an estate. But people without spouses or without adult children, they'll want to name someone to act as their healthcare proxy. And that's the third element of estate planning. Will, power of attorney, and healthcare directive. That gives you the whole wholesome picture of how to plan for the unfortunate events that are coming.
And it's not as though any of us are getting out of this world alive, so I think it's only prudent, and thankfully there's people like you that can help. Is there anything that you can give to anyone watching that would maybe be a first step? You may or may not have Canada Pension benefits, and what happens with those, or any of my assets, my favorite baseball card collection. Should that just be written down on a holograph will if you just want to keep it simple?
Something's better than nothing.
Yeah.
Having any sort of what we call testamentary intention, making it clear where you want your stuff to go, is better than nothing. My best advice as a starting point is to just make a connection. Primarily with a lawyer would be my recommendation. And say, hey, I want a really simple estate planning, or I want a really simple will. Is that something you could help me with? One phone call, a couple meetings, pretty kind of straightforward. You can feel comfortable you've got something in place that is legal and binding. If people aren't there yet, the lawyers are still a little scary, which I hope after this people realize we're not. Just thinking about it on their own. What do I have? Where are my bank accounts? What are my passwords? If something happened to me, where would people be looking? Do people know I have life insurance? Do I have someone named on my life insurance? Do I want someone named on my life insurance? I have debt, I have credit cards, I have a student loan. How are those being covered? Those are sorts of things that I know we don't maybe want to think about, but they're worth thinking about because they just create a headache for your loved ones afterwards.
When someone does draft a will, or you do provide one for them, is it once and done, or do you have to do it every 2 years or 10 years, or maybe a spouse dies, you should revisit it? Is there a timeline?
There's no obligations to look at it at any time or change anything at any time, but you hit it right on the head. Any major life event, a death, a birth, if you've got grandkids or more children are born, inheritances, maybe your stocks go down and you have less. Any major life event, my advice is always to pull out your current will or your current estate planning, brush it off and make sure it still fits with what you need. My other advice is probably about every 5 years. Take it out of the vault or pull it up on your email or wherever you have it, and just make sure it still fits with what you want. It is a growing document. It always is growing with you as your life changes, and the hope is that you get one in your 20s, and as your family grows and you get more income and you have more investments and potentially you have charitable goals, those things can all grow with you along with your documents as you do.
Well, you're making it a lot easier than I thought it would be. But if someone did want more information and wanted to ask you one-on-one, where would they get a hold of you?
They can reach me. We've got a website for Scharfstein LLP, and they can find me on there. We've got a great group of estate planners at our office. Phone number is 306-653-2838. Emails on the website, lsharfstein@scharfsteinlaw.com. And I mean it when I say this is my happy place. I'm more than happy to work with anyone on estate planning early in the process or closer to the end.
Well, thank you for keeping it calm. We really appreciate that.
Thanks, Randy.
Stay with us, folks. We'll be right back.